Welcome to this month's Third Thursday webinar, brought to you by Synergy Settlement Services. The Third Thursday webinar is part of an ongoing free monthly webinar series. Each presentation is done by a Synergy subject matter expert who will tackle difficult issues that arise at settlement. During today's presentation, if you have questions, type them into the control panel where it says Questions. The following brief presentation will give you an overview of what Synergy does in 30 seconds.
A trial lawyer's job isn't to know all the nuances, to know what it takes to keep Medicaid in place or SSI and preserve Medicare and comply with the Medicare Secondary Payer Act and resolve these complicated liens that may be present. So all of those issues are issues that the trial lawyer really doesn't have the time or the expertise to deal with. They need a partner that they can rely upon that can handle all of those issues, and that's exactly what Synergy is.
Thank you for joining. This is Teresa Kenyon, Director of Lien Resolution here at Synergy Settlement Services. We're going to go ahead and get started. This is a third Thursday webinar that we put on every month. We cover different topics related to issues that arise when attorneys are settling claims. We will be open for a brief question and answer at the end of the presentation, so please direct your comments and questions to the questions section. The webinar itself will be added to our website and also sent out to all attendees tomorrow morning. And finally, the presentation slides can be requested if that is something that you are looking for. Today's webinar is titled Handling Medical Liens in a Post-Montanile World. Best course of action is to tackle head-on. Here is my bio slide. I am a licensed attorney in both California and Kentucky. As I've indicated, I'm the Director of Lien Resolution Services. My team specializes in various lien types, including ERISA, FEBA, Medicaid, Medicare Advantage, TRICARE, disability liens. We also handle traditional Medicare. We do audit and verification of claims, as well as waiver compromise requests for refunds from Medicare after the final payment has been made. And just to give a little background, prior to joining Synergy, I was on the other side. I was employed with the Rawlings Company for almost 8 years, representing the health insurance carrier's interest. And now I'm happy to be on the other side, assisting the injured parties and helping them retain as much of their settlement proceeds as possible. And here is the case site to the Montanile case, which will be the focus for today. Before we get started today, I wanted to take a quick look at the other services that we can provide for plaintiff attorneys and their clients. Today we are talking about lien resolution, but we also specialize in Medicare compliance, and we can discuss Medicare set-aside issues, including MSA trust, allocation reports, and MSA estimates. Settlement consulting and government benefit preservation involves the evaluation of cases where injured parties are eligible for public benefits like Medicaid or SSDI, and they need to have those benefits preserved post-settlement. We can advise on the use of a special needs trust or an MSA or other financial tools to ensure that those benefits remain available for the injured party. Structured settlement annuities provide a secure tax-free stream of income for injured parties. We assist with the preparing of all the necessary documentation, and we ensure legal documents are compliant at the time of settlement. Trust services, it's the manner that we ensure that injured parties continue to qualify for those need-based public benefits. And then finally, tax deferral of fees is for attorneys. It's an attorney fee structure, which is pre-tax and tax deferred, and it's available for attorneys who earn contingent legal fees. So the agenda for today is to start with the definition of ERISA, have some discussion about self-funded versus fully insured plans, and then turn to the U.S. Supreme Court decisions involving ERISA, focusing on the Montanile case, and then talk about the health plan's response to Montanile, what kind of practical changes they made in their processes, also the plaintiff attorney response to Montanile, how they may have handled post-settlement liens differently, and then tackling the lien. How do you do it? We will talk through that. And another question, why did Montanile win? What were the pieces of the puzzle? So we're going to definitely look at the facts closely of the Montanile case. And then the cases that have come after Montanile. We will do an overview of those and then conclude, and then finally the question and answer at the very end. So let's get started with the definition of ERISA, or what it is that ERISA stands for. It's the Employee Retirement Income Security Act of 1974, and it establishes the minimum standards and provides protections for employee health care benefit plans. In terms of lien resolution, the subrogation rights of an ERISA plan are loosely defined by federal code, which allows for appropriate equitable relief. And ERISA plans are identified as being either self-funded or fully insured based on the type of policy that is held by the employer. Is the plan ERISA? That is the first question. And ERISA governs employer-employee health benefit plans. There are exceptions. So religious employers would not be covered under ERISA. They would instead be subject to state law. And also government employers. These would be subject to either state or federal law. Just a couple examples: the city of Atlanta or any other city, the county of Orange, the state of Texas. Those would all be subject to state law. Or federal employees would be another government employer, which would not be considered ERISA. Okay, so other government plans: Medicare, Medicaid, not governed by ERISA. Individual plans, also not governed by ERISA. Those type of plans would be individual plans purchased for just one person. They could be purchased in the marketplace through the Affordable Care Act or through a health insurance broker or some other means. So the real question is it self-funded? So a lot of times I will hear people talk about ERISA asking only, is it an ERISA qualified plan, but not asking that next question of, is it a self-funded plan or is it a fully insured plan? And unfortunately, this can be confusing. You will see a lot of the same companies, the same insurance companies for self-funded plans and fully insured plans. For example, United Healthcare, Aetna, WellPoint, Cigna, Highmark, HealthNet, Blue Cross, Blue Shield, Florida Blue. All of these carriers do work for both the self-funded group as well as acting as a carrier in a fully insured situation. So just to make sure we're clear, a self-funded ERISA plan preempts state law, and those claims are paid with funds contributed by the employer and the employee, and those funds are put into a self-funded pool. The insurance carrier involved is only a claims administrator, meaning that they are responsible for processing the claims. They receive the bills and they make payments using the money from the self-funded pool. They themselves do not carry any financial burden for paying those claims. Alternatively, a fully insured ERISA plan is subject to state law, and in those situations, the employers collect premiums and then use those premiums to purchase insurance coverage through the insurance carriers. The carrier themselves is the one that suffers the financial burden of paying those claims. The employer pays nothing else other than the premiums per month. Let's go ahead and take a quick look at the U.S. Supreme Court decisions surrounding ERISA liens that have come out over the last couple of decades. This will be a simplified overview. As you can imagine, a much more in-depth discussion could be had on each one. We're going to start with 1990's FMC Corporation versus Holiday. This was the one where it was stated that ERISA self-funded plans preempt state law. Specifically, ERISA's preemption clause was broadly found to establish an area of exclusive federal concern on the subject of every state law that relates to a covered employee benefit plan. The next one, Mertens versus Hewitt Associates from 1993, holding that equitable relief was limited to categories that were available in equity, such as injunctions or restitution, but not compensatory damages. You could not collect money damages as part of an equitable claim. And then in 2002, the Great West Life and Annuity Insurance Company versus Knudsen. This is the one where there was the holding that settlement funds must be identifiable and within the possession of the party. Essentially, you cannot seek a legal remedy or monetary damages as part of an ERISA claim. And the next case is 2006's Sereboff versus Mid-Atlantic Medical Services, where it was stated that a fiduciary could bring an ERISA claim in equity. It was stated that the plan was not seeking a recovery from the general assets of the injured party, but rather it was an identifiable fund through a constructive trust. And because of that, the plan could follow the identified recovery into the Sereboff's hands as soon as a settlement fund was identified, and then they could impose that trust or equitable lien on those funds. Next is 2013's U.S. Airways versus McCutcheon, and that was the one where it held that the equitable theories like the made-whole rule and common fund could not override clear language of a contractual agreement between an ERISA plan and its members. So in that situation, the policy is the law. And here is a quote reflecting the equitable theory that the plaintiff's bar is looking to have confirmed. In the McCutcheon case, the plan was silent as to a reduction for attorney's fees, and so the common fund doctrine was found to be an appropriate default rule to fill in the gap. But the quote is that third-party recoveries do not often come free. To get one, an insured must incur lawyers' fees and expenses, and without cost sharing, the insurer free rides on its beneficiaries' efforts, taking the fruits while contributing nothing to the labor. And finally, and the focus of today's presentation, the Montanile versus Board of Trustees of the National Elevator Industry Health Benefit Plan, holding that the plan can only seek equitable relief against a particular thing, so an identifiable fund, and not from general assets, but also specifically stating that once the identifiable fund has been spent on non-traceable items like food or travel, then the equitable lien is destroyed. And in the Montanile case, it was found that the plan could not enforce its lien. Let's talk about the facts of the Montanile case. It definitely appears that the facts mattered here, so we are going to go through them in a little bit of detail. So the first basic fact, Montanile was injured by a drunk driver and collected a $500,000 settlement. The health plan paid about $120,000 in medical expenses. The plan did assert a reimbursement claim, but the attorney argued that the plan was not entitled to any recovery. And we'll talk about that detail a little bit later. So the negotiations broke down, and Montanile's attorney advised the plan that he was going to disperse the settlement funds unless the plan's board objected within 14 days. And the plan did not object within that 14-day period, so he did disperse the funds, and then 6 months later, the plan filed an ERISA action. At that point, Montanile's attorney argued that the funds had been spent on daily living expenses and that there was no longer an identifiable fund in which to enforce the lien. So the Montanile decision. The Supreme Court reviewed their previous holdings in the Knudsen case, Sereboff, and McCutcheon, but they distinguished both Sereboff and McCutcheon from the situation in Montanile because Sereboff and McCutcheon were specifically seeking identifiable funds that were within the plan member's possession or control. This was in contrast to the disputed funds in Montanile, which had been dissipated by the plan member before the plan brought its lawsuit. The court recognized that the plan's equitable lien attached to Montanile's funds at the moment in which he obtained the funds. But the court held that because the plan didn't sue to enforce its lien when it was first notified that the settlement funds were in Montanile's possession, or rather in the possession of his attorney, then the plan could not later seek to recover from the general assets under an equitable remedy available under ERISA. An ERISA lien can only be enforced against specifically identifiable or traceable funds within a plan member's possession at the time that the plan seeks to enforce the lien. They can't look to the member's general assets sometimes after they have received the funds. And here's Justice Thomas in Montanile, the holding that when a participant dissipates the whole settlement on non-traceable items, the fiduciary cannot bring a suit to attach the participant's general assets under 502A3 because the suit is not one for appropriate equitable relief. So what was the response? What was the response of the ERISA plan, the health plans, after the Montanile case? So behind the scenes, they're modifying the plan language. They are taking a look at it again and making sure that they tighten it up as much as possible and close any loopholes that may be there. They make sure that they're clearly indicating that the plan is to receive full reimbursement before any funds are dispersed. They make sure that they negate any equitable defenses such as the made whole rule or the common fund doctrine. They have language that says it doesn't matter if you're partially at fault. Other things that just take away any defense that a plaintiff may be able to bring. And then there's also an uptick in future benefit language. So in order for the plan to ensure that they still get paid no matter what, they added language that allowed for a penalty for failure to reimburse by stating that future benefits would be offset by the reimbursement man that was owed to the plan but not paid after a third-party settlement. I've got a snippet here of a policy that has that type of language. So it clearly has the heading, offset of benefits. This is in the subrogation of reimbursement section of the health plan's policy. And we'll just look at it here. So it says, if timely reimbursement is not made to the plan, or if the participant fails to comply with any of the requirements of the plan regarding the plan's right of reimbursement, the plan has the right, in addition to any other lawful means of recovery, to offset payment of any future medical benefits under this plan on behalf of the participant in an amount equivalent to any outstanding amounts owed by the participant to the plan. And what was the health plan's practical response? What type of action was being taken on the front line? Well, first, everyone was clearly objecting to the disbursement of funds. This was happening at the onset with providing a lien or during negotiations. Self-funded groups, their vendors, insurance carriers, everyone representing the plan's interest wanted to make sure that it was clearly asserted that there was an objection to the dissipation of funds prior to the lien being addressed and fully handled. They were also making changes to policy and procedure to ensure that responses were being made timely and that time deadlines weren't being missed or overlooked. Those with authority for approving reductions were making faster decisions, whether that was the recovery vendor internally, the carrier, or the self-funded group. It was stressed that when negotiations were pending, responses needed to be quicker. They were also ready to file legal action when negotiations broke down or when the injured party and their attorney stopped responding. Again, choosing to do this sooner than later when the signs were there that negotiations had taken a turn. Carriers and self-funded groups were more generously providing the plan documents and proof of funding. They were willing to provide affidavits or testimony to prove their position. Overall, there was just a bigger push to subrogate their interests against the third-party carrier to receive those funds for their lien directly, and they were willing to actively litigate their interest. So why did Montanile win? Really, it seems like it's fact-based. In the Montanile case, Montanile's attorney seems to have done all the right things that led to a successful win in this situation. First, Montanile's attorney notified the plan of the pursuit of a third-party liability action. This is required in most policies. It's usually under the cooperation section where it says that a plan member needs to notify the plan. And we'll go over that in a little bit more detail. He also exerted due diligence by cooperating with the plan. He signed additional agreements and provided information that was being asked for. He did make an attempt to negotiate the claim. There were some offers and counteroffers exchanged. They were arguing over the legality of the claim, but there was a good faith effort to negotiate. And then finally, when those negotiations broke down, he gave the plan notice of disbursement and 14 days to object. And the plan, as we know, did not respond. And so those are the facts that do seem to matter. So at the end of the day, it is my opinion that all the pieces of the puzzle need to be present in order to win a Montanile argument. If they're not all there, then it's very likely that the court will not find the same way as they did in Montanile. And as we review the cases that came after Montanile, we'll see that that is the case. Let's talk about the plaintiff attorney response to the Montanile case. And I'm sure that there have been many, but here's just three that we'll talk about here in a little bit of detail. So the first is that some attorneys stopped sending notice letters to plans and recovery vendors, notifying them of a pending third-party liability action. I think the thought behind this was that if you don't communicate about the lien with the possible lien holder, then you can just disperse those funds and not be worried about an unknown lien. This isn't recommended, though. This isn't in line with why Montanile succeeded. Ultimately, Montanile's attorney did notify the plan of the intention to pursue a third-party claim. Other attorneys have taken Montanile as a green light to ignore reimbursement requests from the beginning. So this is when the lien holder themselves finds out that there's a pending claim and they put you as the attorney on notice. Some attorneys started just not even responding to those. Decided that if I don't communicate with the lien holder in the beginning, then when the case settles, I can just still act like they don't exist. It's not recommended, though. It's not in line with why Montanile succeeded. If you recall, Montanile actually cooperated with the plan, provided them information, and was having communications with them. And then the third piece that I have here is that some attorneys decided to just disperse funds immediately after receiving the settlement check, that there was just to be no attempt to negotiate a lien claim and just, again, act like that lien holder is not there. But that's not recommended. It's not in line with why Montanile succeeded. Montanile's attorney did make a good faith effort to negotiate, had legal arguments as to why he disputed the validity of the lien, and was trying to work it out in the end. So what should you do? You should tackle that lien head on. That is the recommendation. So how do you do that? You notify and you cooperate. So notifying the plan is the first step to showing that you're cooperative. It can put the plan or the recovery vendor at ease. And cooperating is sometimes a vague statement in the policy, like do whatever is necessary, but sometimes it's specific. Again, providing information at the beginning of the case creates a good relationship with the plan or with their recovery vendor. So for notify, most policies say you should notify the insurance carrier or the plan of the intention to pursue a TPL case. Example 1 there shows what a policy language looks like. It looks like this one is for Aetna. It clearly says, by accepting benefits under this medical plan, you or your representative agree to notify the claims administrator, Aetna, in writing within 30 days of the time when notice is given to any party of the intention to investigate or pursue a claim to recover damages or obtain compensation due to third-party injuries sustained by you. Most policies have this. If you look at example number 2, the covered person must notify the plan administrator within 45 days of the notice. So most of what I've seen has been 30, 45 days, 60 days sometimes, but there usually is a time limit. The other thing that you should do to tackle that lien head on is to cooperate. Provide information like the injuries. Make sure that you're relaying what the liability issues are on the front end of the claim, not after the case has settled. So have that communication with the lien holder, whether it be a recovery vendor or a group, a plan administrator themselves. Again, most policy language requires this. You can see on example 1, bullet point number 2, Cooperate with Aetna and its designees to do whatever is necessary to secure the plan's right of subrogation and reimbursement under this booklet. That is a generic or vague statement to do whatever is necessary, whereas under example number 2, it is a little bit more detailed. Second bullet point, this cooperation includes providing the plan with relevant information, including information concerning any other applicable insurance coverage that may be available, such as automobile, home, or other liability insurance coverage, and coverage under another group health plan. Also providing the identity of any other person or entity and their insurers. If applicable, that may be obligated to provide payments or benefits on account of the same injury or illness for which the plan made payments. So the policy languages definitely cover this. And again, I want to take us back to the slide. Why did Montanile win? Montanile's attorney notified the plan of the pursued TPL action and exerted due diligence by cooperating. So that is what Montanile did, and that's what would be recommended to be able to rely on a Montanile argument. So what's next? You've notified, you're cooperating, now you need to negotiate. So after the case has settled, you should be making a good faith effort to resolve the lien in order to have that much needed puzzle piece that Montanile had. It's good to try to resolve the lien amicably. It's always better to be able to close your file with confidence. So let's go back to the Montanile facts, because facts matter. So Montanile's attorney was negotiating with the plan. And you can see the highlighted part there. The attorney was arguing that the plan was not entitled to recovery. And what the argument was that the plan was not entitled to recovery because the subrogation and reimbursement language was only in the SPD and not in an MPD. And so per the Cigna v. Amara case, the attorney was arguing that the provision was not enforceable. They were still having conversations. Ultimately, those negotiations broke down, and so Montanile's attorney advised the plan's attorney that because he didn't believe the governing plan documents asserted the proper right and had the right language, that unless they could produce a document that contained that language that he was looking for, then he would disperse the funds on a date specific. And the plan's attorney responded by the deadline and said that the SPD was the plan document. Offers and counteroffers were taking place during this time, but the plan did provide a final counteroffer stating that failure to accept would result in litigation. And that's when Montanile's attorney wrote and requested that if the plan intended to litigate the matter, then it should do so within 14 days. And if they didn't, then he would release the funds. At the end of the day, negotiations take time, skill, and patience. Compromise is needed on both sides, and really negotiation is compromising in order to avoid future arguments and disputes. Although each side's trying to get the best outcome for their client, each side must take steps away from their polar position towards the other party. A plan needs to move away from 100% recovery simply because the policy says that they're entitled to it. And the plaintiff counsel often has to move away from a complete waiver. Unfortunately, we often see this, where both parties are not willing to compromise. And in those situations, it leads to a train wreck. And so just because we're dealing with personal injury, I'm sure we're all familiar with these kind of photos, but this is the end result of a lack of compromise and a refusal to negotiate. All right, so the ultimate goal. Your goal should be to resolve the lien with finality and be able to close your file confidently, knowing it will not come back and it won't take any additional time and effort. You should know, though, that if you go for a Montanile defense, that you need to be prepared for the plan to attack offensively. To have a chance at succeeding, you have to have all the pieces of the puzzle. That final piece of the puzzle is that the plan doesn't respond at all or stops responding. If they are working with you and they're being timely in their responses, then a Montanile defense will likely fail. The final piece of the puzzle is that the plan must fail to respond. So you've notified, you've been cooperating, you attempted to negotiate, and if negotiations break down, you should provide the notice to the plan that you're going to be dispersing funds if they don't object. Montanile's attorney notified the plan of that intention and ultimately followed through on that. You can't just ignore the plan, though, disperse the funds, and hope that the plan doesn't come back later for the money, because they most certainly can. And here is the quote from the Montanile case about the plan's lack of response. The board had sufficient notice of Montanile's settlement to have taken various steps to preserve those funds. Most notably, when negotiations broke down and Montanile's lawyer expressed his intent to disperse the remaining settlement funds to Montanile unless the plan objected within 14 days, the board could have, but did not, object. Moreover, the board could have filed suit immediately rather than waiting half a year. All right, so let's talk about some cases post-Montanile. One of the first ones here is from 2017, HNI Corporation versus Hess. So just some facts. Hess was involved in a motor vehicle accident. The plan paid medical expenses of about $146,000, and they sought reimbursement after the case settled for $200,000. Hess refused to reimburse any expenses the plan paid, so the plan brought an action for equitable relief pursuant to ERISA, and the plan won its reimbursement action and was found to be entitled to its full amount of $146,000. They were also awarded attorney's fees for having to take this action to get their reimbursement. So generally, it's not common for plans to receive attorney fee awards where a plan sues a participant, but here we can see that it's a risk and it can certainly be awarded. So on these, I'm going to do takeaway. So takeaway for the plan administrators. As soon as they see that there isn't cooperation or there isn't some kind of sign that a compromise is coming soon, then they're going to file suit and ask for attorney's fees. What do they have to lose? So that's not good. For the injured party, the takeaway should be that refusing to pay the lien instead of trying to negotiate it runs the risk of the plan just deciding to sue. Not only is there the additional cost of defending the suit, but then there's the risk of needing to pay attorney's fees and costs for the plan and still losing completely. Here, had they negotiated, maybe they could have negotiated paying back $50,000, but instead they rolled the dice and had to pay back $146,000 plus attorney's fees and costs. So not a good situation at all for Hess and the outright refusal to reimburse. The next case is Cognetta versus James Bonavita. So Bonavita was involved in a motor vehicle accident, and while the claim was still pending without any settlement funds yet being available, the plan filed a declaratory action to establish a constructive trust for the benefit of the plan. The injured party responded that this wasn't appropriate relief under ERISA because there was not yet a settlement, and any kind of discussion was just hypothetical future funds that may or may not ever come into existence. The court found that the basis of the claim was equitable because it existed within the terms of the contract. And so the court found that the relief sought was protective, and if funds were recovered, then the plan would be entitled, so they granted the relief sought and they established a constructive trust. So the takeaway here for plan administrators, go ahead and file a declaratory action to establish the trust. You don't have to wait for those settlement funds to actually come to fruition. And it certainly eliminates the plan's concerns about dissipation of settlement funds by the plan participant. For the injured party, the takeaway is now I really have to deal with the lien because the plan administrators can file actions before the settlement pot even exists. And it certainly eliminates the possibility of really using equitable arguments after the case settles to try to secure a reduction. All right, then we've got Carpenter Technology versus WIDA. So WIDA was in a motor vehicle accident, and the medicals were $245,000 as paid for by the plan. After the settlement, WIDA's attorney advised the plan of no reimbursement. The plan didn't respond, so we're heading down the same kind of fact pattern of Montanile. But in this situation, the plan filed suit for an order imposing a constructive trust and an order enjoining WIDA from transferring or disposing any of the settlement funds. But before that suit happened, WIDA transferred the settlement to a joint checking account co-owned with his wife. $46,000 was what was left, and he stated that those funds had already been spent. So he asserts that the funds were dissipated by paying for things like food and gas, utility bills, credit card payments, loan repayments to private individuals. It was also noted that in that same joint account, there were deposits from WIDA's paychecks, his wife's retirement checks, her paychecks, various money going into that same account. And the court ultimately found that the funds were no longer identifiable, and so the plan could not recover under an equitable theory. So for plan administrators, what's the takeaway? It's important to identify funds as soon as possible and prevent those funds from becoming unidentifiable, as they did here. So what does that mean? That means take action quickly. But for the injured party, what's the takeaway? Once those funds are received, put them in a joint titled account, and then they're dissipated, they're considered dissipated, and there's no recovery possible. So it seems like this is supplementing Montanile on how to escape payment of the lien. Take note that this is from the Eastern District of Pennsylvania. Then we have this case from the also from the Eastern District of Pennsylvania. So this is a district split. This case reflects a district split. So in this situation, the Goodspeeds netted $304,000 after the attorney's fees and cost, and the plan had notified that there was a lien of $82,000. They did so prior to the case settling. The attorney went ahead, though, and dispersed the funds and did not reimburse the plan. The Goodspeeds deposited the check into a joint savings account, just like the WIDAs did. And 1 month later, the plan filed an action for reimbursement. So by May of 2018, in the span of October to May, they spent and withdrew more than the amount from the account. But some of those spendings included $200,000 to a certificate of deposit with a right of survivorship, and also the purchase of a van for $62,000. And so in this situation, the court found that there was a specifically identifiable fund. The court was aware of the earlier Carpenter versus WIDA decision that we just discussed, and the similar facts of the joint checking account and the dissipated funds, but they were not swayed by the commingling argument, and instead they focused on the traceability of the funds. So they said here that you cannot transfer an equitable lien to which you are the constructive trustee. They found that the funds were transferred and then dissipated on identifiable items, and in this situation that was the CD, the certificate of deposit, and the van. And so the ultimate finding was that they needed to pay that lien. So at the end of the day, it's not recommended on the majority of cases to rely on a Montanile defense after the funds are dispersed. There's a huge risk of losing that argument, subjecting your client to bigger lien reimbursements, attorney's fees and costs, the uncertainty of having the money after time has gone by. But in the end, what does it really take to succeed on a Montanile argument? Basically, you have to do everything right. You have to notify the plan, you have to cooperate with the plan, you have to negotiate with the plan, and you have to allow time for an objection. The plan, on the other hand, has to do nothing right. They have to have no response and just be radio silent. All those pieces must be present in order to succeed on a Montanile argument. As you know, Synergy handles liens. We get reductions, so we do the lien resolution. And this is just a couple examples of some successes that we've had. Here we've got an ERISA lien of $571,000. This did have a $500,000 settlement. The lien holder's final demand was a three-way split of the available funds, but we continued to push, and through our intense negotiations, we were able to secure a 96% reduction, and we got the lien reduced to $22,000. So this was certainly a nice one. And here's another one. This one is a Medicare lien, but this was a failure to diagnose case. The lien was $184,000. It also settled for $500,000. It was a Medicare Advantage plan, and they were refusing to reduce even for attorney's fees. And again, we made numerous legal arguments and continued to push the issue, and we were able to get this lien reduced to about $6,000, which was a huge savings for the injured party who had already been through so much as part of their med-mal case. This one was also a 96-97% reduction. And we are now approaching our final slides. Just another look at the other services that Synergy can provide for you. As you know, I'm the director of the Lien Resolution Department. And I thank you for joining me today as we discuss the Montanile case and the various issues surrounding handling medical liens in a post-Montanile world. Our recommendation is to address the lien and obtain final resolution that you need to close out your case. Hopefully you learned something, or maybe just had some things that you already knew reiterated. But if at a later time you have questions for me, my email address is on the screen. You can also call in to us, and we're happy to answer questions and let you know what we can do for you on your cases.